Today, US immigration enforcement practices changed following a new internal policy issued by Immigration and Customs Enforcement. The policy allows ICE agents to enter private homes using administrative warrants without judicial approval. This development directly affects immigration enforcement, constitutional protections, and how federal authority is exercised inside American homes. The policy has already been implemented in training materials and limited enforcement actions across several US cities. Civil liberties organizations, immigration attorneys, and constitutional scholars are closely watching how courts will respond. This video explains what changed, why it matters, and what Americans should realistically expect next. Background: under the US Constitution, the Fourth Amendment protects people against unreasonable searches and seizures. For decades, law enforcement agencies have required judicial warrants to enter homes and conduct arrests. Judicial warrants are signed by judges after reviewing probable cause presented by law enforcement officials. Immigration enforcement operates under civil law, not criminal law, which has historically allowed limited procedural differences. ICE commonly uses administrative warrants issued internally by immigration officers, not judges. Until recently, administrative warrants were generally insufficient for forced entry into private residences. Courts have long recognized the home as receiving the highest level of constitutional protection. Immigration arrests typically occurred during traffic stops, workplace enforcement, or voluntary encounters. Forced home entry without judicial warrants has been rare and legally contested in past cases. Latest development. According to Associated Press reporting, ICE issued an internal memo expanding administrative warrant authority. The memo states that administrative immigration warrants authorize agents to enter homes to arrest individuals. The document was distributed internally and incorporated into ICE training and operational guidance. The policy applies primarily to individuals with final orders of removal issued by immigration courts. ICE confirmed the policy after questions arose following a high-profile arrest in Minneapolis. In that case, agents entered a home using an administrative warrant rather than a judicial warrant. Legal advocates argue the action contradicts long-standing interpretations of Fourth Amendment protections. The Department of Homeland Security maintains that immigration law authorizes this enforcement approach. DHS officials have not publicly released the memo, but its contents were confirmed by multiple sources. No federal court has yet ruled directly on the policy's constitutionality. Confirmed facts versus open questions. It is confirmed that ICE issued internal guidance expanding administrative warrant use. It is confirmed that agents are being trained under this updated interpretation of authority. It is confirmed that administrative warrants are not signed by judges. It is confirmed that forced home entries have already occurred under the new guidance. What remains unresolved is whether courts will uphold this authority under constitutional standards. Federal judges have not yet issued binding rulings addressing this specific policy expansion. Legal challenges are expected, but outcomes remain pending. Impact analysis. The most immediate impact is on immigrant households, where individuals have final removal orders. Families may face increased enforcement activity occurring inside private residences. Immigrant communities in large metropolitan areas are likely to experience heightened enforcement presence. The policy also raises broader civil liberties implications beyond immigration enforcement. Fourth Amendment interpretations often influence multiple areas of federal and state law enforcement. If upheld, the policy could establish precedent for expanded administrative authority. If struck down, ICE may be required to revert to judicial warrant requirements. Local law enforcement agencies are not directly affected by the policy. The change does not alter asylum law, visa policy, or border processing procedures, legal and constitutional context. Administrative warrants differ significantly from judicial warrants in oversight and review process. Judicial warrants require independent judicial review to establish probable cause. Administrative warrants are approved internally by agency officials. Courts have historically limited administrative warrants to inspections and regulatory contexts. Using administrative warrants for home entry represents a significant legal expansion. Civil liberties groups argue the policy weakens constitutional checks on executive authority. Government attorneys argue immigration enforcement operates under distinct statutory authority. These conflicting interpretations are likely to be resolved through litigation. What happens next? Immigration attorneys are preparing lawsuits challenging the legality of administrative home entries. Federal district courts will likely hear initial challenges within months. Appeals could eventually reach federal appellate courts or the Supreme Court. Congress may conduct oversight hearings examining the policy's legal basis. DHS could revise or clarify guidance depending on judicial rulings. ICE enforcement practices may change again depending on court outcomes. Until then, the policy remains active and operational. Americans should expect continued legal scrutiny and public reporting on enforcement actions. Closing. This policy marks one of the most consequential immigration enforcement shifts in recent years. Its legality will be determined not by political debate, but by judicial interpretation. The outcome will shape how federal authority interacts with constitutional protections. As cases move through the courts, enforcement practices may continue evolving. This remains a developing story with long-term implications for law enforcement and civil liberties.